So let's say at the point you're like, okay, my freedom is restricted. I know I'm in custody and I want my lawyer right now and I invoke my right to remain silent. And the police are like, haha, sucker. You don't get any of those things yet because we stopped asking you questions. And when we want to ask you questions again, then you tell us that again. But we're not asking any questions right now. You're in custody. We are the Arms Attorneys. Today we are talking about a very recent case that really kicks the guts out of the Fifth Amendment this time.
Normally kicking the guts out of the Fifth Amendment.
Kicking the guts out of the Fifth Amendment. This affects when you get your right to a lawyer and what you have to say and at what time you have to say to properly invoke that right. But before we get started, show your support for the Second Amendment by hitting the like button.
And this is a disturbing trend we've seen since the founding of the country. Guess what? We have these inalienable rights. Hey, government, stay away from these things, but slowly they find all of these loopholes and chip away at it to where, all right, there are more exceptions than the rule. Does the rule even matter anymore? And this is one of those protections that, I mean, is really important, especially if you're a suspect in a self-defense case. I mean, really any case, but a suspect in a self-defense case, because there's this gray area we're going to be talking about where if you don't get it just right and the court performs this crazy analysis, maybe you've implicated yourself in a crime where evidence would have otherwise been excluded.
Absolutely. So,
all right. Did you ever figure out the facts of this case?
I did. So this is a case out of the Texas Court of Criminal Appeals. It is extraordinarily poorly written. Thank you, Texas Court of Criminal Appeals, for this one. I know Richard and I both read it multiple times trying to figure out exactly what they were trying to tell us about the facts. But we have an 18-month-old. This 18-month-old is living in the custody of a woman. Woman lives with her boyfriend. And so what happens is boyfriend, woman, whomever, they all go, they report this little boy as missing. We don't know where he is. Huge manhunt ensues. Neighborhood gets involved. And then he goes up, being the last person to have seen the little boy. He goes up to the police station and is assisting the police with any details that could help them find the little boy.
Yeah, voluntary at this point.
Voluntary, right? And this is at I think it was 2:30 in the afternoon. He starts talking to him, giving him as much facts as, he's got. A couple hours go by and the police confront him with this unfortunate little detail that, oh, the other children in the house have a different story than you. And so we are looking at this as a kidnapping, as a lot of things that could implicate you, sir. So maybe you want to change your story. At this point, he says, I need a lawyer.
But that doesn't stop the police. And we're now around 5 o'clock in the afternoon.
Exactly. Yeah, it's been about 3 hours.
Interrogation continues for some hours.
Right. At which point, when he says he needs a lawyer, they go ahead and they arrest him on outstanding warrants that he has.
Correct.
Right? So not on this case, not on the baby disappearance, but on other warrants. So he is under arrest at that point.
Yeah, he's in custody. They continue to question him for a little while. Then they come and perform a Miranda warning. He waives at that point, and then he gets into some more material. This goes on till 2 a.m. the next day. And
then he confesses to a horrible crime.
Yeah.
This is, how many times do we have to say, bad facts make bad law?
Yeah, and you might say, all right, this is a baby case. What does this have to do with me? Well, all right, this has to apply with when can you effectively invoke your right to remain silent, invoke your right to an attorney. This is focusing on the right to an attorney because clearly he invokes it. What happened at the trial court suppressed, if you're not given your Miranda warning, a lot of people think, oh, they have to unarrest me or, oh, they have to drop the charges. The legal remedy is that evidence collected illegally after, you invoke your rights has to be excluded at trial. It's called a motion to suppress. In this case, the trial court suppressed the evidence saying, hey, guess what, government, you illegally collected or solicited all of this confession material. It appealed, the state of Texas appealed it up. The appeals court agreed, said, hey, guess what? Yeah, you collected this material illegally. They appealed it to our highest court in our criminal land, which is our Court of Criminal Appeals, and the court reversed them and sent the case back down, saying, hey, guess what? We found a workaround to all of this, and it's because he invoked his right at the wrong time.
He invoked his right to a lawyer prematurely because at the time that he invoked the right, he wasn't actually being questioned in those moments where he invoked the right, which is insane.
Yeah.
Insane under the circumstances. I mean, it is. And again, it's I have no love lost for a
No.
no love lost. Like, does this guy deserve to rot in prison first and hell second? Absolutely he does. And I'm not shedding a tear on that one. But this sets the precedent for all of us here in Texas. And if you think that it only affects Texas, you're absolutely wrong, because anytime these issues come up nationwide, the side of the government is going to go pull advisory cases from other states to try to convince their highest court to do the same thing. And then here is another thing that really, I feel like I'm Edwin ranting right now.
Do it.
Here's another thing that really,
Let her cook.
Oh, that really pissed me off about this case is that they did not address a second question here, but the government tried to argue it. And this tells you the state of the Fifth Amendment and what you need to watch out for. Again, Texas and nationwide, is that the state of Texas tried to make the chicken shit argument that saying, I need a lawyer, is not a unequivocal demand for a lawyer.
Yeah, that's pretty wild.
They made that argument. They said, he didn't say, I'm invoking my right to an attorney, or I refuse to speak to you until I get an attorney. He said, I need a lawyer. Sure, that could mean anything. That doesn't mean he wants one right now. Now, the court didn't take that up.
No.
But come on.
Yeah, that's the argument being made. And so, I mean, the court in this case gave us two scenarios when a case becomes ripe for invocation of rights only after Miranda warnings have been given while the suspect is in custody, or if custodial Miranda warnings have not been given when the custodial interrogation begins. And so the court does this really bizarre thing where they say, okay, if he has been Mirandized and then he waives those, hasn't invoked it, well, then you can, all that material comes in, right? And I think that's a pretty clear-cut case.
Yeah, sure.
Here's the second scenario. If the person's in custody and being interrogated, well, it seems like the court did this kind of law-specific, hey, was this guy actually in custody at the time that he was, being there, theoretically, voluntarily? And so to add a little bit of clarification, this was all right, he wasn't in custody, but he was being interrogated, all right, not ripe for Miranda, but then we clearly put him into custody. He wasn't being interrogated, but he was the only thing that saved, so they interviewed him some more. He's basically volunteering information at that point. That stuff's fine. Then we Mirandized him. That's when he has a right to have an attorney. Mm-hmm. And it's this kind of chicken and the egg situation where you don't have a right to an attorney until Miranda is basically provided to you. And then the other situation is custodial interrogation. We'll decide what custody is for, it's almost like a legal analysis. And so it leaves the suspect guessing, hey, when am I in custody? When am I in custody?
And when am I being interrogated? Because that's the part that really gets me, because they do this sort of two-part argument. Well, like, first he was being interrogated but not in custody. Then he was in custody and not being interrogated. So Miranda doesn't apply any of these times. So let's say at the point you're like, okay, my freedom is restricted. I know I'm in custody and I want my lawyer right now, and I invoke my right to remain silent. And the police are like, haha, sucker. You don't get any of those things yet because we stopped asking you questions. And when we want to ask you questions again, then you tell us that again. But we're not asking you any questions right now. You're in custody. Doesn't apply. I mean, it's just, you have to be a legal scholar to figure out when your rights have attached. And if you do it prematurely and then you're like, well, I did it, I don't have to do it again, joke's on you. Joke's on you. It just is, it's outrageous.
Yeah, because, all right, and maybe you've seen this stuff in maybe like First Amendment audits online, things like that. And you hear this question, am I being detained? Am I free to go? And the reason that people ask that is to establish, all right, you are not free to leave, you are in custody. So we've kind of checked that first box. Well, then interrogation. Well, are they asking you questions? Yes. All right, well, then it's likely that, hey, guess what? You are being interrogated at this point. We have this long line of cases saying, oh, they're asking you about a different incident, not the incident you're in custody for. Well, then that doesn't actually apply. So you see this kind of shell game the court is playing, and it's a really, really dangerous precedent. I mean, how do normal people know whether or not to invoke their rights?
They don't. And I'll tell you, I'll throw another wrench into what Richard just told you, which is when you ask that question, and when you see the First Amendment auditors, this is generally the situation. I mean, if you're sitting at Houston Police Department homicide floor, and you say, am I in custody? Am I free to leave? That's a good indicator of whether or not you're in custody. When you're a First Amendment auditor or the like, and you ask it on the side of the road, likely what the police are going to tell you is, You're not free to leave, but you're being detained for an investigation. And does Miranda kick in?
No.
Nope, because although you are not free to leave, you are not in custody. You're being detained for an investigation. You might ask yourself, what's the difference? And that's an excellent question. I'd love to hear someone articulately explain it to me, but there you have it. You really do. Go to law. You want to have rights? Go to law school. That's what I get from this.
All right, to run through these real fast, here's when the courts have previously held that people are in custody when the suspect is physically deprived of their freedom in any significant way. When a law enforcement officer tells the suspect they cannot leave, minus out the tensions there. When the law enforcement officer creates a situation that would lead a reasonable person to believe that their freedom of movement has been significantly restricted, or when there is probable cause to arrest and law enforcement officers do not tell the suspect he is free to leave.
Yeah, so that actually is the one. So I will say all those first three, like the roadside detention, or you call the police because you've had some sort of incident and they detain you, like this does not apply to any of those detentions. That last one, though, actually is something that we get to argue in court pretty frequently, because a lot of times officers are chattering between themselves and they're like, oh yeah, no, he's going to get arrested.
He's going in.
Yeah. But once they say that, and then they start asking you a whole bunch more questions, then it gives the lawyers the opportunity to say, okay, now, this was not a detention for investigatory purposes any longer. This was custody. You should have read his Miranda. And those are winners.
Yeah, and I would say, all right, let's bring this to a head with what can you do as a normal person? Say you're being custodially interrogated. When are your Miranda rights triggered? All right, well, we know custody, interrogation. If you have any question about that, hey, am I free to go? Am I in custody? Am I under arrest? Those are good questions to establish. Hey, guess what? You're in custody. And then them asking you questions at any point in time, the court's going to hold that's going to be an interrogation, especially if it's related to the incident. All right, so those are kind of your telltale signs. It doesn't hurt to invoke your right to an attorney unequivocally. I invoke my right to an attorney. Don't say it any other way. You see the court try to wiggle and the state try to wiggle their way out of it. I invoke my right to an attorney. I invoke my right to remain silent. And then actually remaining silent, don't engage anymore. And this is the last...
Or, here's what I'll say.
Okay.
This is practical legal tip.
We used to do that.
We used to do those. Anytime you are in this situation and the officer asks you anything, your answer is, I invoke my right to an attorney and I invoke my right to remain silent.
Yeah.
Every time they post something to you, that's your answer. And then it doesn't matter when Miranda attaches because you're saying it constantly.
Yeah, I think that's solid. Every single time, great response. But the last part of this is, all right, and this is what they did in this case. It didn't attach here, it didn't attach here, it didn't attach here. Then we Mirandized him and he waived it. Never waive it.
Never waive it.
What a big mistake that was.
Well, but also at that point, and again, with no sympathy to this person, at that point, it is like, what, 2 a.m?
Yeah.
It's like 1, 2, 3 a.m. The reason they wear you down on purpose.
Yes.
They wear you down on purpose. He knew what to do initially in order to disguise his, crime. I know, like but here we are. You defend the rights of the horrible person because otherwise it degrades the rights of everyone.
Yeah, and maybe your states have extra rights, like Texas. I invoke my right to an attorney. I invoke my right to remain silent. I invoke my right to terminate the interview. Every single time. I think that's good advice. Good job, Kimberly.
Thank you.
But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And please question and comment for us below. Until next time, we're the Armed Attorneys.